Thank you very much, Franca. Let me use the opportunity to commend the Legal Education Committee that is ably led by my dear brother and friend, the learned brother Silk Damilola, and the very excellent team that he has put in place, the NBA has put in place. Let me also thank our keynote speaker for his very insightful remarks and for setting the stage for this panel conversation. Let me thank all the participants that have made our time to join us on this webinar. With particular reference to your question, Franca, and especially given my current position as the chairman of the Nigerian Law Reform Commission, what I would strive to do is not so much to take a position about some of the most critical issues that are embedded in the question that you have raised. So I'll try very briefly to flesh the issues and leave them open for further conversations, because at some point, these issues might come before me in an official capacity, and I don't want to be seen to be taking a position that then puts me in a bind when this gets back to my office. But I think that for anybody that has followed the state of legal education in this country, and in the specific context of the imperative need to train lawyers for global competitiveness, I think that there are a number of key issues that are key. Among them is actually what very many people see as the monopoly that the Council of Legal Education, and especially the Nigerian Law School, has. There are debates that are ongoing regarding the propriety of that, whether in fact we shouldn't begin to license other service providers. Of course, there's always the danger that a profit motive then undermines the whole initiative. But I think that it is important that we constructively engage the subject of what, as I pointed out earlier, many see as the monopoly of the Nigerian Law School. And in fact, if we are to deal with this in a very profound manner, that also has implications for legislative initiatives, because the current regime that you have is largely predicated on the Legal Education Act, which is as old as 1962. So I think we need to engage that conversation in a very profound manner, whether we should begin to license other service providers, in which case the Nigerian Law School ceases to be the sole institution with responsibility for vocational training of lawyers in this country, in which case the Council of Legal Education remains. And I've had the privilege of serving on the Council of Legal Education, first as Attorney General, as Dean of Law, as an NBA representative for about 10 years. So I have a sense of the workings of the Council of Legal Education. But the Council of Legal Education remains as the regulator within that broad spectrum. I think that conversation needs to be taken forward. The other point is the subject of continuing professional development. And this is something that, thankfully, even though had faced a bit of resistance, is now increasingly being institutionalized in a very profound manner, thanks partly to the efforts of the current administration of the NBA. And you would see that quite a number of individuals have keyed into this webinar, and it earns 1 point. So there is considerable progress that is being made in that respect, but there is still room for improvement in terms of the mechanisms through which we can ensure that these continuing professional developments are fit for purpose. The third issue that I would flag very quickly is what is ongoing, incidentally, and I think I must underscore this fact very quickly, is the fact that there is currently an executive bill, if my recollection is right. I'm not sure whether it's an executive bill, but I think it is, given that it was placed on the floor of the Senate by the Senate leader, that seeks to amend the Legal Practitioners Act. And some of the issues that are being addressed within that framework, for instance, deal with the subject of pupillage. Now, there are those who are already, there's considerable pushback But it's part of the conversation that we need to have, whether post call to bar, new weeks are then obligated to serve a period of pupillage, whether it's 1 or 2 years. That is a subject of engagement currently before the National Assembly, and I think we need to deal with this subject. But the fourth issue I'd like to flag very quickly is the point made by our keynote speaker about reciprocal recognition of qualifications and creating the kinds of special dispensations that would enable those that are not ordinarily called to Nigerian bar, for instance, to have some opportunity to practice in this country. At some point, there was a proposal, I think there was some memorandum of understanding between Nigeria and the United Kingdom, and it generated a lot of controversy. Now, I believe that what we need to do is not to completely throw the baby away with the bathwater. What we need to do is to see how we can ensure that should we go down that route, we do so in a manner that does not allow global law firms to predominate and to undermine the opportunities that we'll obtain. But can we do so in a manner that creates an environment in which we can have a mutually reinforcing engagement so that foreign lawyers, for instance, are able to practice to an extent in our jurisdiction, and then Nigerians on a reciprocal basis can also have a similar opportunity. I had the privilege of serving as a member of a high-profile committee that was set up by the president of the NBA then, Abi Mahmood, led by Tony Idibe. And one of the issues that came up was whether we have too many lawyers in this country, or whether, in fact, the reality is that we need to improve the market for legal services in this country. And so that's an issue that we need to engage. And the conclusion that we drew was that it's not that we have too many lawyers in this country. In fact, relative to our population and relative to the legal issues that are often generated in our polity, we don't even have enough lawyers. But have we created the market for legal services that would respond to the realities of the Nigerian legal landscape? And this is a conversation that we must have, not only in the domestic context, but also in terms of engagement with the opportunities that we may have for reciprocal collaboration or some mechanisms for cross-jurisdictional practice. As a teacher, I think that one of the things we need, and I come down, so I'm beginning to move from the regulatory framework to engage some of the reform initiatives, and I hope that I can do so very quickly. And I had the opportunity to address the annual general conference of the Nigerian Association of Law Teachers about the imperative need to prepare even the law teacher for the realities of 21st century legal education. And for me, one of the starting points is, what is the integrity and rigor of the recruitment process? Because for me, that's extremely critical. So for me, what is the integrity and the rigor of the process through which we recruit our law teachers? And what is the integrity and the rigor of the process of career progression? You are told that you either publish or perish. But what is the quality of some of the materials that we use as a basis for promotion? Are we simply publishing with a view to promotion? Or are we publishing in a manner that is fit for purpose, that also keys into our national development plans? But of course, as our keynote speaker has pointed out, it is also the imperative need to constructively engage the subject of curriculum review, especially given the realities of technology, given the need for comparative jurisprudence. But the other point, very quickly, is the need to fundamentally address the subject of pedagogy. How do we make sure that our students learn law by doing law? And that brings in issues like clinical legal education, and so on and so forth, and how to ensure that our teaching methodology is not just theory driven, but that in fact it engages the students in a manner that enables them to solve issues and to approach law from a mindset that enables them to create a laboratory of ideas. And I'll raise two other issues and then I would yield. Is the need to ensure that we have accountability and oversight mechanisms that work. And this has to do, for instance, with the subject of work ethic. And this is a very serious problem in public institutions. The private institutions are a bit better. How do we ensure that we have accountability and oversight mechanisms that hold people to account, to make sure that they do their work, that we elevate the quality of their work ethic, for instance? What are the accountability mechanisms that ensure that we do not create a toxic environment within which our students should learn? What are the mechanisms that we have in place that ensure that we are able to harness, and ensure that the feedback of our students count in course in course generation, in course selection, in even in promotion, for instance? What is the input and the feedback of our students in terms of these realities? And when I speak about mentoring, I often quote Isaac Newton, the famous scientist, who said the reason he was able to see far into the future is because he had the privilege of standing on the shoulders of giants. And one of the most critical challenges is whether, as law teachers and very senior practitioners, we're providing our giant shoulders for these young ones to stand on, to dare to dream, to be the best they can be and better. I will yield at this point, and I hope that we'll have an opportunity to then engage what the pathway forward is in ensuring that we build law students and build a generation of law practical competitiveness. Thank you very much.
Thank you so much, Leonard Silk. Very, very insightful answer. And yes, we will get back to discussing the pathway forward. It's on my list. But if I can ask Professor Ibironke a question. Professor Ibironke, I hope you can hear me. I just want to confirm.
Hear me?
Okay, yes, okay, I can hear you, ma'am. So I was going to ask, drawing from your experience in the Canadian legal academia and, international economic law, how do universities in developed jurisdictions integrate international and comparative law into their core curriculum? Some lessons that developing countries like Nigeria could benefit from. Thank you.
Thank you, Dr. Iguela, for that question and for the introduction. And I want to thank Professor Olawi and the committee for the invitation and for these informative sessions that the Legal Education Committee has been holding. I attended one of them a few months ago, and it was just as informative. So thank you. I'm particularly glad to be responding to this question and to be part of this conversation today, as legal education is very dear to me. And it's great to be in the company of people like Professor Dakas, who I believe I met in Osgood some years ago, and of course Professor Ofodile and
Yes.
Professor Qureshi. I've professorized him, and Mr. Qureshi, who gave that wonderful keynote earlier in this discussion. And I would say, like he said, that for me, it's predictably cold here on a December morning in Canada. To respond to your question, Dr. Aguila, I must first say that or observe that the legal education that I received at the University of Lagos, my LLBs from the University of Lagos, was an excellent springboard for my graduate studies abroad. It created a world of opportunities for me, but that was about 25 years ago. And times have changed, things have shifted. The world looks different today than it did a quarter of a century ago, just as Professor Qureshi was mentioning. So legal education must also look different, and it must be approached with the realization that the world keeps shifting, and our students who become lawyers would often encounter international, comparative, and cross-border issues in their work. So legal education must be able to respond to these realities. So often, the international, comparative, and cross-border issues that are encountered are economic in nature. They don't always have to be, but they often are. And I'm taking a very practical approach to your response. I like the way Professor Dakas has framed it for us, but I would take a very practical approach. Some of the relevant courses that need to be part of the curriculum, Professor Dakas was talking about pedagogy. I would actually go a step further to outline some of the relevant courses, and some of them exist in several universities in Nigeria. For example, public international law. I took this course about a quarter of a decade ago at UNILAG. It's the basic springboard for the kind of global practice that we're thinking about, or private international law, conflict of laws. I took this course at UNILAG as well. But then we start to get into areas that our keynote speaker, our distinguished keynote speaker was talking about, like international investment law, international arbitration. Nigeria has been a party to some of these arbitrations over time, international trade law, business and human rights, a lot of which is determined by global standards, not necessarily national or local standards, general ESG considerations that Professor Lawi was mentioning earlier. You can't do business transnationally these days without some ESG considerations, intellectual property law that I know that many Nigerian universities have. But these are not the types of courses that remain static. They're always changing. So for law teachers, last year's notes and examples will not suffice this year because they keep moving very quickly. And even beyond these types of courses, foundational courses like contracts that I teach here include references to international principles, treaties such as the UN Convention on Contracts for the International Sale of Goods, and those types of documents, right? So even when we start to teach classes like contracts, we need to already start to build that global mindset into the teaching so that the students can start to appreciate the global nature of the work that they will encounter in practice. And beyond courses, though, universities in developed jurisdictions, as much as possible, ensure that students have significant opportunities to put their knowledge into practice while they are still students. And this is a major difference from the experience of many students in Nigeria. And this already presents a kind of leverage for these students that study in developed countries, so that by the time the students have completed their legal education, they would have encountered opportunities that some of their counterparts only read about in books. So for example, like very practical examples, Professor Dakas mentioned clinical legal education. Yes, absolutely. So let's talk about internships. Internships with major organizations such as UN agencies. And these opportunities exist or potentially could exist on a larger scale on the African continent. So for example, think about the Africa Development Bank. Think about the Secretariat of the AFCFTA, the African Continental Free Trade Area. It's just in Accra, right? The African Union, regional bodies such as the ECOWAS, right? Abuja, arbitration institutions in Africa. Some of them are in Nigeria, right? Chambers of commerce. Students could be introduced to working with these types of bodies even while they are still students, and that would greatly enhance their legal education. Students in my part of the world often take on summer positions with law firms. By now, this is December, some of them are already beginning to apply for jobs that they will take on even while still students in May, June, July, and August of 2026. Some of them already know those jobs that they're going to be doing during those times. These positions position the students quite well, or even paid research assistantships with faculty, with their professors, with their lecturers, right, that are doing some of this work or doing some of the research. But of course, that becomes a resource issues or competitive moods beyond trial advocacy. So I know that Nigeria teams participate in the Jesup Moot, for example. But beyond the regular trial advocacy, we need those types of moots that focus on negotiation, that focus on mediation, which are quite important in cross-border transactions, or some of those moots that focus on economic matters, securities moots, corporate law moots, right? We need greater opportunities for these types of engagements to better position our law students. And then law review journals. In my part of the world, students often serve as editors or participants in law review journals where they're exposed to international and comparative work that very well-known experts publish. They're exposed to work from other jurisdictions while they are still students. And there's also a certain leverage, and this is not compulsory by any means, but there's a certain leverage that most Nigerian students do not share, that students in places like North America have. And that is that most of them already have a degree before they become law students, and it positions them to be better able to compete. It was our keynote speaker that was talking about competition being a good thing. So we have to ensure that our students have to be able to compete. And as I start to bring these remarks to a close, so some of the best practices for preparing our law students then would include access to legal resources, right? And as the keynote was talking about, these resources are often available online. So there's Bailey for English courts decisions. There's Canley for Canada, for example, right? So there's access to what is happening out there. There are websites that would publish for free. If you go to the website of the UNCITRAL or UNCTAD, for example, you would find international arbitration decisions that are widely available, right? Yes, not all the resources would be freely available, but there's access to lots of these resources. And then the ability to use and navigate these legal research resources. I've encountered some of our students who sometimes have graduated from a 5-year law degree, but have not really been exposed to writing. So I would call for better exposure to writing. And then the awareness of and the ability to navigate multiple legal cultures. And that's one of the things that some of the students in developed countries have. Just by being in classes, just by engaging with their counterparts from different countries, they have a keen awareness of other people's and their ways. So we also have to start to develop that exposure, that openness to legal cultures from different parts. And the last point that I would like to make is that a balance between homegrown and continental approaches and international approaches is necessary. I am someone who a lot of my research is based on Africa and what happens in Africa, even though I live and work in Canada. And you'd notice that I've referenced arbitration centers in Africa. I've referenced Africa's continental free trade area. I've referenced the African Union, the ECOWAS. These all form part of international practice, even though they're continental, and they help present an identity that is not always beholden to everything foreign. So I'd like to leave us with this thought. Even though we're talking about global practice, and that is necessary, what I believe we need is the versatility to navigate local spaces, continental spaces, and global spaces and practices in this era. And I think that that is key: the local, the continental, and the global. The versatility to navigate that is key in this area. Thank you, and I look forward to further discussion.
Thank you so much, Prof. While you were speaking, I could relate so much because as somebody who is part of a Nigerian University law faculty, there are a lot of things that we could implement from all the things as you said. Thank you so much. My next question is for Professor Fodile. And I want to ask, as an academic, how do you see legal education evolving to meet the demands of globalization and transnational legal practice, considering your experience and your background with Nigeria? Thank you so much.
Prof, you're muted.
Okay.
Can you hear me?
Yes, Prof, we can hear you.
All right. Good morning, everybody. I just want to say thank you for this invitation to talk and to participate. I really welcome it. Like other speakers, I grew up in Nigeria. I'm a product of UNN. And I went to Nigerian law school, and I got a very wonderful education, an education that really positioned me for continued growth. From Nigerian law school, I went to UCL in London, and then I did my LLM and PhD from Harvard. And it was all because of the foundation from UNN. That is to say that I want to preface for everything I say by saying that we have the foundations right in Nigeria. And it's that foundation that has propelled a lot of Nigerian students to do very well overseas. That said, we're in a new dispensation. Things have changed. So nothing that I say today should be taken as denigrating Nigerian legal education. But times have changed. So we need to think about changes. I will start by a few years ago, actually 2024, Bloomberg Law had an editorial titled "How Law Schools Are Preparing Students for the New World of Work." And they were primarily focusing on US law schools. But the point is that across the world, law schools are thinking about the evolution, the changes in the marketplace, the changes in the consumers that we serve, and how you can adapt to that changes. So, as an academic, what are these changes? I will say also that I have a quote from Stanford Law School where it said that all 21st century lawyers are likely to face transnational legal issues and must be prepared to engage with people, legal systems, businesses, governments, and multilateral institutions from around the globe. So, what is the evolution that I see? I see a lot of changes. I will also say that many years ago, more than 20 years ago, I had a lot of conversations with my dad, who happened to be a law professor. And I was a bit frustrated with the inflexibility of the Nigerian legal system. And I was asking him why there's no change. And he felt that there was changes, but it's incremental. So what are the evolutions in legal education? I think one of the biggest changes we're going to see going forward is the role of technology in legal systems and in legal education. I see the world moving towards an AI fluent ecosystem. I see changes in curriculum. Not some of them may be radical, but I see a lot of changes. I see changes in pedagogy, and some of the other panelists have already touched on it. I see changes in partnerships that law schools are building. And finally, I see changes in the networks. And by networks, I mean things like alumni networks. I will just start because I don't know how much time I have. I'm going to start with just technology. If you looked at the headlines in August 2025, Harvey, which is a big AI company and AI tool, there was a big headline that they published. It says, Harvey launches academic program with law schools at Stanford, NYU, Michigan, UCLA, and Notre Dame. That was in August. In November 2025, there was another headline. Harvey expands law school program to the UK. And this included Oxford University, the King's College, and some of the top universities. Now, how did Harvey explain this? What is this program? It says that Harvey is excited to announce the launch of its Law School Alliance program, embedding its leading generative AI technology into law school curriculum. By making technology a fundamental part of law school education, these institutions are innovators in helping prepare the next generation of lawyers for careers where technology enables and supports more of their legal work. Finally, Harvey also talked about that this collaboration will equip the next generation of lawyers with essential generative AI skills. Apparently, the plan is that Harvey will work with the law schools to co-create generative AI curriculum and learning content. And as I was reading this, my thinking was, wow, Harvey, a big Gen AI company, is essentially collaborating with law schools in Western world where they actually revamp the curriculum and where AI is now an integral part of and is helping to create legal content and legal education. I think that technology is really one of the starting points, just even based on my own stay here in the West. I have a colleague whose office is right next door to me. He teaches about 200 students in Ukraine and Eastern Europe. He teaches them legal writing, I think, twice a week from his office. From his office next to me, he's teaching about 200 students legal writing. From his office next to mine, he also teaches about 100 students negotiation. And I've been thinking about it. And I was thinking, what are the obstacles to these engagements in Africa? Because technology has broken a lot of barriers. So I think my remarks, I'm going to be raising a lot of questions, really questions that we need to ask ourselves because we know the problems. So one of my questions is, what are the challenges to leveraging technology in legal education in Nigeria? Are these challenges resources? Are the challenges infrastructure like electricity? Are the challenges like internet? What are the challenges and why is it, and what are the obstacles to overcoming these challenges? I think some of these questions, to answer some of these questions, we have to bring some of the big heavyweights into the room. The students, I've always known Nigerian students to be vibrant and very keen to learn, but our Nigerian students are swimming against all odds. Our Nigerian students are trying to compete in a face of so many obstacles. Let's think about the basic Nigerian law school, not even the private schools. We're talking about the public institutions. Do they have electricity? Do the law schools have constant internet connection? Do the law schools have the books available for the students to compete? These are just basic questions that sometimes when we ask, people get, how do you say, maybe embarrassed, maybe annoyed, but these are questions to be asked. What stops collaboration between Nigerian law schools and the big Gen AI companies that are now coming up? So that is just my first question that I think when it comes to technology, technology is going to be one of the big evolutions in the future. And if Nigerian law schools and Nigerian universities are not positioned to capitalize on it, we will be losing a lot and we'll be doing a lot of disservice to our students. The next thing is really the issue of curriculum, which my colleagues have talked about. One thing I want to say is that when it comes to curriculum, many law schools have really progressed significantly. I see innovation not just in the core courses, I see innovation in the electives that they're teaching, and I see innovation in the way that they're bringing teachers from across the globe to teach it. I'll give you some examples. In one of the law schools, the University of Cincinnati Center for Global Practice of Law, they have at least 4 core courses: human rights, public international law, IBT, and immigration law. But then they also have so many electives. Electives like international tax, international intellectual property, international arbitration, international criminal law, international environmental law, and it goes on and on. So are we ready? And I want to say that sometimes it's about how you leverage your assets. It's not so much about, okay, we cannot compete with the universities in the West. It's about how we leverage the assets that are already available locally, regionally in West Africa, continentally in the whole of Africa. So one of the things I would like to talk about is really our collaboration with our sister law schools in West Africa and the rest of Africa. Let me give you another example. Michigan law. Michigan law has introduced a lot of classes and courses. For example, Michigan law teaches Africa in the global legal system, Chinese law and legal institutions, comparative human rights law, Islamic law, tribal law, transnational law, law and economic development in India, all at Michigan Law School. So that is what I want to talk about curriculum. Let me talk very briefly about networks and partnerships. Again, I just want to use examples from other law schools just as a sense. A lot of law schools in the West have a lot of money devoted to what they call development and alumni and just connecting with alumni. They spend a lot of money connecting with their alumni and getting their students plugged into things out there. So for example, Michigan Law, they have the Michigan Law Student Organization. They have the American Society of International Law, where they've partnered with the American Society of International Law to provide reduced cost for the law students. They have the Washington Foreign Law Society. They basically have partnered with so many organizations so that their law students can have networks. So my question again, I always ask questions is, how are the alumni networks that we have? Nigeria has produced so many strong, top-notch lawyers that are scattered around the globe. How are the law schools, what type of resources are they investing to identify their alumni, to connect with their alumni, to get their alumni to invest in the institution? If they are not already doing so, that's a lot of resources that is being wasted. That is a lot of resources that is not being connected. I am an alumni. And I don't know how many times my own university has reached out and said, hey, can you speak? Can you teach a class? We don't have money to pay you, but if you're willing, not once. And I don't want to put anybody on the stand, but how many times, how many law schools have reached out to their alums and said, please, we are needing this. We need people to teach these classes. We don't have money to pay you. But if you're able to teach it, we can promise to put your name up on our website. There are many foreign Nigerians outside who are willing to teach for free. And I will say my own experience is that Nigerian universities are not always welcoming. Many times when you offer to teach for free, people say, they have come again. Oh. There must be something in it for her. There's no reason, how can somebody want to teach for free? So sometimes you feel like you're up against the world. It feels like your offer to help is seen with deep suspicion. And it seems as if some people that are on the ground see you as a competition. What I want to say is that when it comes to revamping our curriculum, when it comes to getting our students ready for international practice, there's no competition here. Let us see how we can maximize every available resources, technology, alums, and every other resources. Let's see how we can use the resources that are homegrown. Over here, I have a colleague who takes students to the IC, the International Court of Justice in The Hague. Another student takes students to the International Criminal Court. But as my colleague already said, we don't have to go all the way to The Hague. We have the African Commission. We have the African courts. They're all homegrown in Africa, and for a fraction of the cost, we can do it. So my question is again, what are the obstacles to change in Nigeria? What are the obstacles to curriculum changes in Nigeria? These are the key questions. I understand that under the new changes, the law universities have 30%, there's 70-30, where 70 of the curriculum is fixed and 30 is actually up to the discretion of the dean. Within that 30% discretion, there's a lot that can happen if we can just collaborate and engage in serious conversations. I think the last thing I want to say before we move on is the idea not just of technology, not just of curriculum, but of pedagogy, which is something my colleague has already talked about. When it comes about pedagogy, let's think about experiential learning. And that is one thing that most of the law schools over here are focusing on. Again, I want to give you an example from Cincinnati law. What is their own experiential learning? They have what they call the summer experience outside of the United States. They have the Bogota short courses. They have the moot court. They have the annual meeting of law students where they engage with other law students. Can you imagine an annual meeting of law students across Africa or even West Africa? Do you imagine how much it will benefit our students to expose them to legal education in Ghana, in Kenya, in South Africa? They have externships. They even have partnerships with law firms where law firms come in and teach, and their students go to the law firms for experiential learning. So I'm going to stop here. One thing I would just write to conclude with is, one, what are the challenges to change? What are the challenges, and how much of that challenge is our own homegrown challenges? And two, how do we leverage our own homegrown resources for change? And the third thing I want to raise is the issue of resource constraints and ethnic, religious, and geographic obstacles to change in Nigeria. I just want to mention that because I know these are hot button issues, and I'll come back to them later. Thank you.
Thank you so much, Professor Fadile. That was very rich. I wish we had all afternoon because we could discuss so much more. But I would move on to, I'll go back to Professor Dakas. In view of all that you said earlier about all the certain issues that we have with current legal education framework, what are some of the ways you think we can move forward? What are some of the pathways that we can use to implement some of the suggestions that you gave us earlier to, resolve some of the challenges that we're facing right now?
Thank you very much, Franca. I think that implicit in my earlier remarks, I think there's a sense in which, other than the regulatory issues, I articulated, in a sense, my views about some of the issues, whether you are dealing with the integrity and rigor of the recruitment process and career progression, curriculum, pedagogy, and the imperative need for accountability and mentoring. I think implicit in my remarks were certain pathways forward. I chose not to stake a position regarding the regulatory issues for the reasons that I articulated. But I think
Yes.
that I'm very excited that my co-panelists have addressed some of the key issues. But I'll just take a
Yes.
moment to just draw attention to some opportunities that are out there and some lessons that we can learn from developments in other jurisdictions. I think the point that has been made about networking is extremely important. And I saw that recently. I had the privilege of the opportunity to testify at an exit arbitration proceeding at the World Bank in Paris recently as an expert on Nigerian constitutional law. And over the course of my engagement with the team of lawyers and colleagues that were involved in that process, I could very clearly see the imperative of networking. And let me also say very quickly on this point, there is a very famous saying that your net worth is proportionate to your network. So even from a financial point of view, this is an extremely important issue that we need to take forward. I think it's important, as Professor Fodile has pointed out, the need also, the framework for faculty and staff exchanges, for instance. Of course, in the Nigerian context, that would invariably also require stability in the academic calendar. At the University of Jos, for instance, we had some level of student exchanges with a Chinese university. But then, because of the instability in the academic calendar, it was truncated. And so that's something that needs to be addressed. But in terms of the opportunities that are out there, I had the privilege of serving on the governing council of the International Association of Law Schools. And within the framework of the International Association of Law Schools, there are opportunities for faculty exchanges, for instance, and I hope that colleagues will take advantage of such opportunities. But as the other panelists have rightly pointed out, the reality is that the future of legal education and legal practice is technology. Of course, we have to use technology responsibly, as we have seen clearly with the misuse of AI, for instance. And I saw the benefit of leveraging technology several years ago, even before we had the challenges of COVID and the onset of Zoom and other virtual platforms, when, as Professor Ibiranke has pointed out, I had the privilege of the opportunity to engage with my colleagues at Osgood at York University in Canada. And we were able to get some funding. Professor Obiora Okafor and I were able to get some funding that enabled us to actually teach human rights virtually. And it's so more than 10 years ago, before all these onset of virtual opportunities for learning and engagement, we had the Osgood JOS virtual platform for learning. And Professor Okafor, I would go teach in Canada and then return to Nigeria. Professor Okafor in Canada, I in JOS. And then at the postgraduate level at that point, we were able to engage the postgraduate students at the University of JOS with the students at as Osgood. And it's interesting, we documented our experience and published it in the German Law Journal some years ago. And so there are opportunities and platforms that are there that we need to engage in a very profound manner. But let me then say this on the part of the pathway forward regarding global competitiveness and our engagement on the global stage. And I think this also flows from the point made by our keynote speaker. It's the imperative need to take credibility seriously. Nobody is going to engage your services if you don't have credibility. And that's where the subject of ethics becomes extremely critical. A few months ago, I had the opportunity of engaging the subject of credibility at a platform organized by the Body of Benches. And I recall what I said, and I would like to reinforce that. And I said that no amount of legal brilliance can take the place of ethical fidelity. And so the subject of ethics is extremely critical, not only within the Nigerian municipal regime, but also at the regional and global level. If you have credibility and you bring to the table competence in addition to credibility and the kinds of networks that are critical, then there is no way you will not excel in terms of global competitiveness. So I like to urge colleagues to take the subject of networking, the subject of credibility, anchored on ethics, extremely importantly. And I would just say to our colleagues, especially law teachers in this country, and I pointed this out at a forum a few months ago, about the need for us to take interdisciplinary research that leverages on research grants very seriously. I think one of the challenges that colleagues grapple with within the Nigerian context is that the capacity in terms of research grant writing and attracting grants that broaden the framework and the scope for us to engage in an interdisciplinary context, not only with colleagues within the Nigerian domain, but also in terms of our engagement with colleagues overseas, is one that is extremely important. I'll just say finally that, as the keynote speaker pointed out, he says the moment he ceases to learn anything new is when his practice ceases. I like to take it a step further, that in the context of lifelong learning, the reality is that you cease to learn new things only when you have gone to the great beyond. And I think that we need to take lifelong learning extremely seriously. Yes, within the Nigerian context, the foundation, as Professor Fodile and Professor Ibiranke pointed out, the foundation that was laid several years ago is important, but the times have changed. But some of the things we learned last week or even yesterday, the realities changed literally, and law teachers sometimes grapple to catch, they're really playing a catch-up game with technology. And I think that we need to be on top of our game. And I believe that an opportunity such as this, that the Legal Education Committee has provided, and I believe will continue to provide, in addition to other initiatives, will position us and reposition us to be more forward-looking, more forward-thinking, more proactive, and more constructively engaged, and be prepared for global competitiveness. Thank you.
Thank you so much, Leonard Silk. That was a wonderful answer. Because of time, we're going to open up the floor for question and answers from our participants. So anyone who has a question for our speakers, go ahead and drop your question in the chat or raise your hand so we can direct your questions to the panelists. Thank you very much. Because I would hate to be the only one asking them questions today, even though I am happy to.
Dr. Agrela, there's a question in the chat box. I just drew your attention. Someone put a question.
Okay. All right. In the context of continuing legal education, what international human rights legal education courses are available for us to apply for? In the context of continuing legal education, what international human rights legal education courses are available for us to apply for? Professor Ibironke, if you want to take the question.
Yes, sure. Thank you. So I would say that international human rights, of course, is key. And I like this question that is directed specifically to human rights, right? And the courses could vary from a regular graduate program that one could apply for, even in Nigeria, for example, or in other African countries or outside the African continent, to shorter term type courses, right? So for example, or even seminars or conferences, right? So often there would be conferences that are organized around the subject of international human rights. There might be courses that are organized around the subject of business and human rights, for example. So I think, yeah, it was last year, May, that we were holding a workshop at the University of Cape Town on business and human rights, right? So sometimes some of these events will pop up, and this is where we get to leverage technology, because a lot of that information will be out there on the internet, right? Based on your networks, based on groups that you are a part of, and they would circulate them. So for example, Professor Olawi has a very good social media platform that on the International Law Association of Nigeria, and they would always post information, daily information. Those people who work on that platform do work full time on this. They will post daily information about courses available, events that are ongoing. So it's being able to plug oneself into some of these groups that would provide the opportunity to garner the kind of information that you need to find available courses. So yes, regular graduate level programs, but even shorter term courses, seminars, conferences. Yes.
Thank you so much. Thank you. Mr. Lufemi, you.
Yes, I'm here.
Yes, please go ahead
I'm
and
here.
ask your question.
Can I ask my question?
Yes, please.
Yes, I want to appreciate the learned prof and the learned Silk, Professor Dakas, for their contributions. My question is this: what steps have been taken to brighten the optics of Nigerian lawyers on building a global law practice using the platform of MBA branches? Thank you very much. Am I clear?
I'm sorry, could you repeat that?
Do I need to ask again?
Yes, please. I didn't hear
Okay.
you.
What steps are being taken to brighten the optics of Nigerian lawyers on building a global law practice using the platform of MBA branches?
Okay, thank you very much.
Thank you very much. I'm grateful for the opportunity.
No problem, sir. Professor Dakas, Leonard Silk, if you don't mind.
Well, thank you very much for your comment. And your question in particular. I don't purport to speak for the leadership of the Nigerian Bar Association. And I may not be privy to all the initiatives that the NBA has in terms of its engagement with the branches. The one thing I can say is that I think that there is some level of constructive engagement that is ongoing regarding how best we can, to use your words, brighten the optics of the branches. And I think that when you see the intentionality in terms of the engagements with the branches, I think that that's something that is important. And let me say this in that respect. I know, for instance, that some of the branches of the NBA are in a position, for instance, to offer CLE accredited programs. And I think that through that mechanism as well, the more these CLE accredited programs are being anchored by the branches that have been licensed to do so, I think it then raises and enhances their profile and visibility. And so in terms of brightening the optics, the very busy ones, the ones that clearly understand what their mandate is and their mission, the more they engage globally using virtual platforms, for instance, and other opportunities that the leadership of the NBA provides, I think it enhances, by enhancing their profile and visibility, it then also brightens, to use your word, the optics. And when we engage at fora such as this, then it also then helps us to also see what the gaps are. Because it's important that while we leverage the opportunities, we must also be very deliberate about understanding the gaps and how best we can address the challenges that come with the global competitiveness of Nigerian lawyers, not only at the branch level, but also at the national level. Thank you.
Thank you so much, Bernard Silk. The next question I'd read is, what competitive advantages can Nigerian lawyers bring to the international market, especially with the rise of international law firms opening African offices? Professor Fadile, I think this would be a wonderful question for you. You know, you emphasize so much on collaborations.
Thank you. Nigerian lawyers bring a lot, but because we definitely have a sound education that
Yes.
are relatively cheap compared to what people pay in other parts of the world. To get a Harvard law degree will cost you thousands and thousands. So for now, I think we need to appreciate that we have a relatively cheap education in Nigeria. So the Nigerian lawyer that has passed through the system is definitely very qualified and can bring a lot to the table. There's no doubt about that. But I also want to say that this conversation that we're having today is about plugging in the gaps. Because when a Nigerian lawyer, I don't take any Nigerian law school, putting aside the private ones, the public ones are not offering the deep rigor, the deep curriculum, the deep experiential learning that counterparts in India, in China, are bringing to the table. So in as much as I feel like I want to praise all of us, I also want to highlight that there's a lot of work to be done. I don't know how I can walk that fine rope so that we end this session knowing that we are able and we're equal to the task, but we are short on many levels. Professor Dakas talked about credibility, and that is one thing that we need to think about. The credibility, because I've read some call for papers from Nigerian lawyers, from Nigerian teachers, and you're looking at it, you're like, wait a minute. There's just a problem here. Let's be very honest. So I want to bring up just several issues. One is the issue of transparency. Most of us do not know the budget of the Nigerian law faculties. We don't know who controls it. We don't know how much goes to UNN Faculty of Law, How much of that money is for student development? How much of that is for faculty development? I'm saying that from the part of the world that I am teaching in, there's full transparency about funding. That is one thing that we may be a hot button issue that all of you might be saying, please don't talk about it. But I have to talk about it. So transparency is something, transparency about funding, because you can't hold somebody accountable if you don't know how much money they have to operate with. I don't know. We don't know. We cannot say, oh, the dean of UNILAG should provide electricity nonstop when we don't know the budget. So I want to start with just transparency and maybe encourage the NBA to push for more transparency in the legal education. Second, I want to suggest to the NBA the idea of actually ranking the universities. I know that there's already some ranking, but the ranking of the law schools and to show the metrics for ranking. That will help us know which law schools are falling behind. The metrics could include curriculum. The metrics could include law review experience. The metrics could include experiential learning. So that is one thing I want to suggest. The third thing I just want to suggest is the idea of training. And the last question, you might think I'm not answering your question, but I'm actually answering your question. So when it comes to training on training, here in the United States, students have law review experience. From the second year, students are actually reviewing most of the law reviews that you hear about in the United States, Harvard Law Review, Yale Law Journal, Stanford Law Review. Nobody really knows that these are actually run by students, law students. These are not peer-reviewed journals. So by the time a student goes to 2 or 3 years reviewing, these are students reviewing writings by top professors. By the time you finish, do you know the kind of experience you will have had? That is why when somebody graduates and says, I was the editor of Harvard Law Review, everybody looks at, just bows, because we know what that means. And my colleagues that are on the same panel with me will understand what I'm saying. So basically what I'm saying is that we can deal with the optics of Nigerian lawyers. We can leverage and enhance, but at the end of the day, there are gaps that needs to be addressed. And it will start by transparency, extreme accountability, comparison. Maybe I dream of a time when we can compare all the universities or law faculties in Nigeria and even compare them to the ones in Kenya or Ghana. Because comparison has a way of shaking you and getting you to wake up. Thank you so much.
Thank you so much, Prof. Because of time, we can't take any other questions, but we have had a very, very insightful, very enriching discussion this afternoon or morning in some places. And I would like to, some people were not here from the beginning, so I'd like to give just a little summary of the key takeaways from all the discussions we've had today, from our keynote address to all our panelists. So kicking off things with our keynote address from Professor Qureshi, he emphasized how important it is to open yourselves to international opportunities, to open yourselves to not restricting yourself to only practicing in the box that you were taught to. He mentioned how the barristers' chambers that he opened some years ago was the first one to be opened outside of England and Wales. He actively sought experience and legal work outside of England and Wales. He was going to England, he was going to the US, Botswana, India. He pushed himself to go beyond what he was taught in school. So we are encouraged by him to not be stuck he even lets us know that he has visited Nigeria. He praises Nigeria as one of the beacons of international arbitration in Africa. He mentions that we have every capacity to be the international lawyers that we want to be. We just need the confidence, and we need to step outside of the box. Attending webinars like this, doing courses, going the extra mile, doing pro bono work for international clients. This is how you put yourself out there. This is how you become able to compete with the big law firms, And then when we spoke when Professor Dakas spoke to us, he mentioned all the different, some of the issues that we have in our legal education framework, and also implicitly mentioned some ways that we can resolve those issues. He discussed the issue of the monopoly of the legal education. He mentioned, the issue of continued legal education. A lot of us here, Nigerian lawyers, are here because it is mandatory to have a certain number of CPD points by March. And so this is one of the ways that we have been encouraged through the current MBA administration to continue to learn, to continue to expand our horizon. And one major line that I've drawn across all the speakers has been technology. Professor Qureshi mentioned AI, using AI, but not depending on it so much that you are losing critical thoughts and critical thinking skills. We've talked about how Professor Ofodile told us that her colleague is from the office next to her teaching hundreds of people in different parts of the world. So these are some of the things that some of us who are law lecturers or legal practitioners, we can use the internet, we can use technology, we can use Zoom, use all these apps that are available to us to increase our reach beyond Lagos and Port Harcourt and Abuja. We can spread our wings via the internet. So if there's anyone here who is still not computer literate, I think we can say you're behind. So one of the ways that you can push is learning how to use some of these technological advancements. Professor Ibironke mentioned different ways that our faculties can improve how their curriculum. And I was particularly interested in how she said it's in North America, before you get a law degree, you have to already have a degree so that you know that you're able to meet the high standards of a legal education. It's not something that we do in Nigeria, but I think it's a very good system, And another thing that they practice in North America is very practical internships. There are a lot of opportunities for students to practicalize what they learn so that you're not just reading textbooks and reading judgments from the beginning of your law degree to the end. If we can include practical internships with different organizations, international organizations, African organizations, this will be something that would help us to learn better and eventually increase our capacity when we become practicing lawyers and we see that we can compete internationally. There is no time to go through all this, but I must mention this because it was very important to me when I heard it. Professor Fodile mentioned how we don't, as universities in Nigeria, utilize our alumni resources to the max. 2 out of our 3 panelists work and live abroad, but they went to university, got their LLB degrees in Nigeria. So these are people who are still connected to Nigeria, still interested in giving back. It's important that these Nigerian institutions reach out to their alumni and use them essentially, make use of the resources that they have, their connections. I am part of a university faculty of law, and it would be wonderful if we can organize a seminar where an alumni who works abroad can come in and speak to us. It increases what we learn. We learn about their international practices. We get first-hand information about what it's like to practice outside of Nigeria. These are the types of things you will use to become a global practitioner. So in order to save time, I hope that we were able to learn as much as we could today. I'm going to be handing over to the chairman of the Legal Education Committee, Learned Silk, Professor Damilola, to round up and give us his closing remarks. Thank you so much to the speakers. We really appreciate everything that you told us today.
Thank you
Professor.
very much. Thank you very much. We are so privileged to have had such a remarkable session, and you will agree with me that one thing that our speakers all have in common is that they have moved their careers as practitioners and scholars beyond their countries of backhaul to attain global recognition and success beyond borders. So if they could do this, everyone attending today can aspire to do so too. Starting with the powerful and insightful keynote lecture by Professor Kawa Qureshi, King's Counsel, which emphasizes the need for lawyers to have a global mindset by staying engaged with conferences, knowledge exchange programs, and networking platforms required to provide risk-free legal advice in today's globalized legal market. I think the professor has also stressed a wide range of things on how we can reform education to meet these realities. I've also had the great pleasure of hearing directly from academic leaders in and from Nigeria. We thank the distinguished learned Silk, Professor Dakas, CJ Dakas, Senior Advocate of Nigeria, our mentor, our role model, the Chairman, Chief Executive of Nigerian Law Reform Commission, for taking his time to be with us today. We also thank Professor Ibironke Odumosu, my dear sister, Professor and Associate Dean, Research and Graduate Studies at the cold country of Canada, the University of Saskatchewan. She is indeed a thought leader in areas of international energy and environmental law. We also thank our professor, our dear Professor Uche Ewelukwa Fodile, United Nations independent expert on the Working Group on the Rights of Peasants, and the E.J. Bob Professor of Law at the University of Arkansas School of Law, United States. I would stress that both Professor Fodile and Professor Mosuayana are joining us at very, very inconvenient time in the part of the world that they are in, but they have indeed stayed with us, and we appreciate the rich comparative perspectives that they have brought, touching on Canada, United States, United Kingdom, and beyond. So we thank you indeed for kindly honoring our invitation. We have had more than 300 people attending today, and I can see that you have remained online, and the excellent questions you've asked, ranging from the issue of regulation, cost, infrastructure, technology, indeed shows the interest you have in this issue. I will also say a big kudos to our eloquent moderator, Dr. Franca Iguela, for the great job done. And I can see that your fans are already dropping comments, hailing you for the great job you've done. So on behalf of all of us in the Legal Education Committee of the MBA and the MBA Institute of Continuing Legal Education, I want to thank all of you for your insightful contributions and for joining us. And I can assure you that the discussions of today will be taken forward by our committee for robust implementation in line with our mandate, which is to develop MBA's position on the reform of legal education in Nigeria. We look forward to having you again with us in our next session. And please stay in touch. To stay informed about our upcoming activities, do not hesitate to follow us on social media, on Twitter, X, on LinkedIn, on our community, on WhatsApp. And of course, you can also send us an email if you have further questions. Ladies and gentlemen, dear colleagues, I thank you all very much for joining us, and please do enjoy the rest of your evening. Bye now.
Thank you, sir.
Thank you
Thank
so
you.
much, bro. Thank you, everyone.
Thank you.
Thank you, everybody.
Bye.
Bye.
Thank you. Bye-bye.